For the Women's Legal Centre. She joins us now from Cape Town. Sanja, a very good morning to you. What's tragic here is that South Africa was named the rape capital of the world in 2012 by Interpol. 65,000 rapes were reported. Of those, only 4,500 rapes resulted in conviction. So clearly a massive disconnect is what we're seeing on the ground. Why is this?
I think that the reasons are manifold, and perhaps the most important one is that we need to look at how these crimes are being investigated and how they're being prosecuted. There's widespread dissatisfaction with the manner in which rape cases are investigated at the present time, specifically with regards to forensic evidence, the gathering of forensic evidence, the fine combing of the scene of the crime, the way in which that evidence is then handled, and then also right down to the way in which people who have accused others of rape, the actual complainants, are being treated at police stations, the way in which they're being interviewed, the way in which their statements are being taken or not taken.
Sanja, what's also fascinating here is, depending on the judge, at least this is what we hear, really depends on the sentencing down the line. Is that what is happening on the ground?
Look, in South Africa, I think that we are supposed to have really stiff sentences for rape in this country. We have what we call a minimum sentencing framework that forms part of our legislation. And in terms of this framework, it's very clear that rapists, first-time rapists, are meant to get a minimum of 10 years. A second offender is meant to get a minimum of 15 years. A third-time offender, an absolute minimum of 20 years. And there is even provision for life sentences in serious instances that involve, for example, gang rape or a victim that is under the age of 16 years. And the reason I think why we're seeing a departure from these minimum sentences is that there is a provision that allows a court to depart from a minimum sentence where the court finds that there are substantial and compelling reasons for why such a departure might be necessary. The problem is, I think, the factors that the courts tend to take into account when we're looking at what constitutes a substantial and compelling reason. Now, the Act makes it very clear that there are certain things that can never be substantial and compelling reasons for departing from a minimum sentence. For example, a pre-existing relationship between the perpetrator and the victim. That can never be a reason to depart from a minimum sentence. At the end of the day, I think that sentencing is still largely at the discretion of the courts, and we need to look seriously at what we consider to be substantial and compelling reasons, and reason enough to depart from the minimum sentencing framework that we have already put in place to make sure that perpetrators of these crimes are punished.
Sanja, I mean, let's talk about these pre-existing relationships. What we've also heard is if it happened in the auspices of a pre-existing relationship, the sentence is far lower. What are some of the cases that have really surprised you over the past while? We've even heard if the person is related to you and it's been happening over a long period of time, that actually gives you a lesser sentence. Is this true?
Well, like I've said, it's not supposed to work that way. And yet we see this playing out in practice. And I think this is cause for some investigation into, what we truly consider to be substantial and compelling circumstances, and then also to look again at the section of the Act that gives us guidance as to what can, in fact, never be substantial and compelling circumstances and cause to depart from the minimum sentencing framework. Something that we see rearing its head quite often in South Africa is also this idea that if there's no serious physical injury, then there's cause for a lesser sentence. And that kind of a position just reinforces myths around rape. The myth in this instance being that there will always be a serious physical injury that is attendant to rape, whereas that is not the case. That is simply not how rape plays itself out in practice, and serious physical injury is by no means a prerequisite.
The National Prosecuting Authority has spoken about a specialized sexual offences court. Do you think this is going to be fast-tracked given the most recent drama that we've seen in South Africa?
We certainly hope so. The sexual offences courts have proven to be very effective in successfully prosecuting these crimes, and we really hope that some more thought will be given to fast-tracking the process.
Thank you, Sanja. We have to leave it there. Much appreciated for your insights. Sanja Bornman, the Women's Legal Centre, joining us live, of course, talking about some of the conviction rates in South Africa.